Vedo che... Scusa, sono entrato nella lezione online. Non so perché, ma il computer si è scollegato anche a voi dalla...
Yes, I'm trying to find why we don't have the video. I don't realize why. Let's see, start video. Yeah, okay. Sorry. Can you see me now?
Yes.
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 Okay. Sorry, just I don't know. There was some setting that wasn't there. So we were looking yesterday at the issue of, well, there are only 30. 1 second, just give second of 1 minute more, because you only, I don't know, I hope it's we somehow can 34, 35, 36. Yes, so everybody's joining now. Please register on the chat so I can see you, and I can see who's here and who's in here, and so I know more or less. I can check now. Chat, who's writing here? Hi, yes, okay, that's fine, thank you. That's great. 42. Oh, okay, then.
Però allora adesso sto parlando anch'io, mi sa.
Yo, wherever it is, the microphone is open, so don't say foul words or.
Non so se sono muta. Ah, mute.
Oh, you're not mute. Sorry. Whoever it is. Okay. Now we are, well, 46. Well, good afternoon to everybody, and we're going to resume our lesson where we left yesterday, looking at insolvency regulation.
Cosa? Che succede?
Non ce la faccio.
Can you please? Sorry, please mute your. And okay. So we're looking.
No, va bene.
Sorry. Can you please close your microphone? Please close your.
No, veramente no. Ognuno sai.
Someone has them.
No, nessun problema.
Please close. Who is it speaking?
Faccio una doccia, lo faccio.
Yes, so.
Lo faccio.
No, tranquillo.
Vado.
Can you? Okay, then let's get back to the slides and look a little bit at what we were doing yesterday. Just let me go down where we've gone over 100 slides. I don't know how, but we have gone. Oh, just go back 1 second. We were looking at the company. I just wanted to show you. Remember, the day, well, we were talking about yesterday, we were talking about the fact that in Europe, the whole idea is that of protecting the founders of a company and allowing the company to remain within the family itself. And so I mentioned in a slide, I mentioned a series of companies. I've just made a slide. Obviously, I'll be sending it to you. These are the top family businesses in Europe. And if you look at them, you see that many of them are, the family can keep hold of that company with a very, very small number of shares, relatively small. As you see, the Pietsch family holds control of Volkswagen, which is the main world producer in automobiles, with only 32% of the shares. Agnelli keep hold through Exor, they keep hold of Fiat and Fiat Chrysler, only 30%. Peugeot family keeps hold of Peugeot, with only 30%. Bouygues, which is in France, which does well most telecommunications, and others even less, 27%. Bettencourt, L'Oréal, 31%. Heraeus, which is precious metals, 25%. Michelin, 27%. So this gives you an idea of how you can, the whole system, not the whole system, but the system is significantly organized in order to ensure control of a company with a limited amount of shares. Just so you realize what is the focus. While in the US, the idea is that of tradability, of contendability of the companies. Here, the idea is that of instead of ensuring continuous control of one group, a family group, over the company itself. Now let's go back to insolvency. We were looking at, just let me go back, sorry. Yeah. Sorry. We were looking at insolvency law, and so how we have moved from the idea that insolvency law was there only to protect creditors, and therefore was the harsh law of against debtors who were sent to jail, or anyone dispossessed of all their estate in order to repay the creditors. Here we see that growingly, especially over the last decades, there have been much more wider interests, which have brought to the idea that the company is better that it lives and goes on operating, and therefore the whole insolvency law, from bankruptcy, which means winding up the company, closing it, it stops all its activities, and the liquidator is there to sell all the assets and distribute the revenue among the creditors. Here we have the idea of curing insolvency and finding the way to continue the activity of the company and its productivity, whether it's goods or services. So as you see, it's a very significantly different approach. And this means that creditors are not those who are really in control of the operation. They have a certain saying, but that's not only what they have to they're not the only interests that are protected. And so what do we find out? That we look at a whole lot of institutions. Sorry, there's a so what do we have? We have, as the procedures change from simple bankruptcy to a whole lot of pre-bankruptcy procedures, and the whole idea is that of somehow curing the insolvency. We have the courts, but the courts are there to somehow appoint someone who can manage the company also in a moment of difficulty. And there are various institutions, typically committees of creditors, local authorities, and political instances. As I've mentioned, increasingly, insolvency becomes a social and political issue at both a local or a national level, and therefore the idea is not that so much of protecting so much the creditors, but of protecting the economic fabric of a country, of a region, of a town. I mean, just think of what's happening now with the coronavirus situation, dramatic economic situation. We will have a whole lot of companies which are unable to operate. How do we, should they all go get destroyed, eliminating workplaces and any activity? Well, no, it's not a good idea. Probably there will be someone who will step in and say, we must try to help these enterprises come out of the difficult period in which we are and have a fresh start. So, and this is clearly a very political issue. I mean, the quarrel that there is between certain EU countries and other EU countries on the way to solve, to reanimate economy after the crisis has to do also with that. Now, a further element that I would like you to keep in mind is that insolvency has very much to do with company law, and therefore how you manage a company in the moments of financial distress. But it has a lot to do also with private law, because this module is devoted to private law institutions and their relationship with the economy. And typically, anybody who has made credit to a company has some kind of security. The security may be a mortgage, may be a pledge, may be some other personal guarantee, a bank guarantee. So what do you do? The first, when a company starts having difficulty in repaying its debts, generally what happens is that the creditors, especially banks who know very well if money is coming in or if there's no more money, the banks immediately go, and banks can't be fooled. It isn't that you say, oh, but I'm paying. They see very well how much is on the bank account of the company, and if it is actually receiving credits or not, it is receiving monies or not. So the banks, the first thing they do is they go and collect their guarantees. So what is the first legal step that must be made is a freeze on forfeitures and foreclosures. Forfeitures is when you forfeit when there's a pledge, and therefore you grab the pledge and you bring it to yourself. You've left family jewels in the bank to guarantee the loan you've received, and the bank says, okay, then you're not repaying this loan. Well, I'll get hold of these, the pledge, and I'll sell them and make and have my credit repaid. And foreclosures, obviously, when you the action of selling the assets that have been given in securities. So the first measure that we find in all countries in Western legal traditions is that when a company starts becoming insolvent, what you want to do is avoiding that there's a rush, especially by those who hold the security. And therefore, there's a freeze on these activities. And a typical example that we find is that of the so-called Chapter 11 in the US. Chapter 11 is a Chapter 11 in the US bankruptcy law, and Chapter 11 puts the so-called says that the company is under the protection of the court. So nobody can, even if they have securities, they have guarantees, mortgages, pledges, they cannot execute them. So that freezes activity, and that means that the company is there, and then we shall see what must be done. If the company can continue to be managed, if insolvency can be cured, or instead, if actually the company has to be dissolved, liquidated, and well, then we'll see what the role of the order in which holders of mortgages, mostly banks, pledges and guarantees, will be satisfied if company is liquidated. Now, this is all to do with private law, because obviously mortgages, pledges, and securities are a significant part of private law institutions. When we study contract, well, we always study also all the issue of securities. It's not only a problem of financial law, it has to do with solid private law. This is a very political issue, establishing who are the creditors that have preference over others. The idea that is very well expressed in let me see if I can write something. Just 1 second. Just let me write here on the board. Why don't I have the board? Yes, here we are. Sorry. Obviously, Latin expressions as usual, but we love everybody here in Europe, across the Channel and across the Atlantic. We all love Latin. Par condicio creditorum, which means the equal standing of all creditors. Now, this is wishful thinking. It says that, well, the theory is that all creditors should be on equal standing, and therefore, if the assets, liquidate the assets have are 100, and my credit is 10% of the total debt of the company, well, I will receive only 10. I won't receive more. Even if my credit was 1 million, obviously I will only receive 10% if that is my share. So this is the idea of par condicio creditorum. But as this is a very nice principle, immediately you find everybody's equal, but like in the Animal Farm by George Orwell, some are more equal than others. And therefore, the system goes, sorry, I missed so the problem of order, who is satisfied before? Those who hold a mortgage, should they be the certain creditors? Think of employees who should receive their pay. They haven't been paid their salary for 2 or 3 months. Should they be referred? Or just think of the tax authorities that haven't been paid taxes, or even more welfare funds, pension funds, health funds. They say, hey, listen, we need this money, the money that should have been given to the National Health Service, to the pension scheme have not been paid. We need this money to pay pensions and to pay health to workers. So it is a very political, in a proper sense of the term, to decide who should be preferred, which classes of creditors should be preferred, and what is the order of preference, and the amount of what they should receive. So just to point out that this, when we see this very typically private law institutions of mortgages, pledges, and guarantees, and put into the system of bankruptcy, we see a very complex operation that has to be attentively studied, and all those who study bankruptcy law are very careful in these aspects. And also, if you are a financial institution and you are lending money, well, you want to be sure that this money comes back to you, because otherwise you'll be liable. Then there's a further instance that you should consider. Now, what happens we have standalone companies. So there's a standalone company, which just think of a single restaurant or a shop that is under shape of a company, and that company goes bankrupt. Well, it's only one company, it's standing alone. There are shareholders behind it, the owner, which has quite cautiously separated his or her estate from that of the company, because the company is a limited liability company. But often in medium and big size groups, well, a company is part of a group, and therefore there's a holding which holds the shares of various subsidiaries. So what is the strategy in a holding? when you start seeing that there's a certain risk, what you try and do is transfer the risk on a company which becomes a bad company, which somehow goes, at a certain point you let go, and if it were like a boat that is too full of debts and you let it sink, and you say, oh well, I've lost all the investment I've made on this in this company, but I'm not going to repay all the debts of that company. This is when the shareholder of a company are not individuals but another company. So what happens with this strategy, which is very common, it is a way to get rid of risks and put in all the debts on a bad company. Well, nobody likes this except for the company, the holding company itself, because all the creditors, whether it is the workers or the banks, financial institutions, or the tax authorities or whatever, they don't like the idea that someone gets rid of all their debts and just leaves this boat, this big boat full of debts, sink, and nobody recovers any, not even 1 cent. So there's a growing activity by the courts saying, hey, listen, you have tried to transfer all your debts that you should have paid. You tried to transfer them on this subsidiary company, and you let this subsidiary company collapse, sink, and therefore you are not, this is a way to avoid paying your debts. So just to point out that when it comes to insolvency, so you see that insolvency law, I'll just go back to the slide before, you have to distinguish between debtors, standalone company, company that belongs to a holding, small and medium-sized enterprises, consumers. So we will somehow diversify. Bankruptcy law, insolvency law is not the same for any kind of debtor. And when it comes to insolvency of one company in a group or of a group, well, you try to understand where the monies have gone and what is the system through which. Generally what happens is that someone somehow runs away with the good part with the profits and leaves the debt to someone, to the creditors, and so their credit remains not paid. So just to show you that it is very complex, both from a technical point of view, and this is why you are studying law, and that's why we need lawyers to understand bankruptcy law, the intricacies of bankruptcy law, but at the same time, there's a very significant political and policy issue deciding who you want to somehow favor, guarantee, rather than others. I mean, there are some classes, they could be consumers, they could be workers, small enterprises. So what you want to do is trying to decide who, in the event of insolvency, who are the groups that should be more protected. So this has to do with insolvency. Now, just wanted to just do a brief stop and see if there are any questions on this part devoted to insolvency. I realize it can be very technical, though when you will study company law, you will see also part of the also the issue of insolvency, but it is unfortunately, it's we don't have to look only at physiology, we also have to look at pathology of companies, and therefore we better know also what happens in the case of insolvency. Bad company. Okay, Panagia asks, what is a bad company? Let's take a typical example, which we've had many examples in Italy, but also in other countries. There's a bank. A bank lends money, and obviously it lends money and then it expects to be repaid. But when typically financial crisis, it is not repaid, then the bank finds difficulty in repaying those who have put their money, the depositors. So the people have put deposit in the bank and they say, I want my money back. Now, you must think that generally a bank, it isn't the bank that has a deposit of 100 lends 100. Bank, let's say, it lends, if it has 100, well, it lends 500. Why does it lend 500 more than the monies it holds? Because it feels it is confident that those who are to whom the bank has lent the money will repay, and so there will be a constant cash flow. And so even if those 100 start asking for the money, well, they will have their money back. But if there's a crisis, a financial crisis, the bank is not able to repay its depositors and therefore is insolvent. So someone comes up and says, listen, another bank says, I will buy this bank, but I'm not going to buy all the debt this bank has. So what do? You transfer, the bank transfers on a new company, a bad company, all the debt, and this company will start through various ways, will start repaying its debts, while the company which has all the business relations and all the credit relations will be the good company and will be bought, incorporated, merged with another company. This is what happened with, just say, Banco di Napoli, Banca Popolare di Vicenza. We find a whole lot, and this also in other parts of Europe. The idea of a bad company is a company which holds only the debts. There are only debts and there are no profits. And so what you do, then you start selling the debts that are in this company, and you somehow get rid of it as if it were somehow some kind of malignant tumor, and you cut it off and you put it aside and say, well, we'll see how we can solve this, while the other part of the company, which is a good company, can continue to operate. So you try to separate the profitable business from business which is negative. This clearly needs, obviously, legislative and political support. You can't just put up a bad company and say, oh, but I'm not going to pay my debts because all my debts have ended up in the bad company. But in certain circumstances, both legislation and the political instances, the administrative instances, say, well, listen, it's important that this company goes ahead, so we'll do a good company that is profitable and can be on the market, and we're going to put all the debts in a bad company, and these will be repaid slowly with time being. So we somehow separate the two aspects. Now, this is very, very complex, but if you look at what happens quite commonly in certain insolvency procedures, this is what the way to continue activity. The idea of a bad company is also, however, a stratagem by holdings, that is a group, to say, well, if I have risky activity, I'm going to put all this risky activity in a certain company. I think I'm contracting with the big company. Instead, I discover that I'm contracting with a subsidiary, and the big company says, oh, but listen, this contract will be made with, and you will be paid by this company so-and-so. And so the big company, the holding, somehow pushes all the situations, the risky situations on a company that then eventually it can get rid of, as if it were you have a flotilla of ships, and then you see that one ship is rotten, and you just cut the rope and let it sink. So it is a very not very scrupulous technique, but it's very much used when a company, just think of a company that is involved in, well, in environmentally complex production. And so they say, well, listen, if we have, someone's going to ask us for damages, well, they're going to ask this company and not us. So you try to somehow put the risky activity in a company and the less risky in another company, because you know that you control everything, and when you want, you can get loose, get rid of the risky activity. This is exactly why when we look at insolvency law, the insolvency law and holdings, well, the courts are, and obviously the creditors, mostly we're talking of tax authorities, welfare funds, trade unions. They say, hey, listen, this is not the way, this has been, this holding has tried to not to pay its debts by pushing all the debts on a bad company, and they say, oh, I'm not going to pay these because these your debtor was that company. No, it wasn't me. It was that company, and that company's gone bankrupt. So, well, you will go through liquidation. You will see the liquidation procedures and see what you can get back. Obviously, nothing. So, just to show you that the law tries to tries to counter these techniques in holdings by putting all the risky eggs in one basket and saying, well, it breaks, well, not my problem, someone else's problem. So let's go back to then to what we get to discuss now. Sorry. Now, what we've seen until now is that we've been looking at private law through the lenses of economy. And so trying to see how much the economic system influences the legal system and how much the legal system influences the economic system. And one of these aspects, which is extremely important, which has to do with the exercise of state authority, but also with, obviously, with private law, is regulation of economic activity. If you remember, we've been looking at regulation, looking at it from the administration point of view, how the administration is a public institution which regulates economic aspects. So we have, this has always been part of state activity, and states have always, that means for the last 4,000 or 5,000 years, have always been regulating economic activities. For example, establishing that you could produce or you could not produce certain goods, what could be imported, saying these products can be imported, these products cannot be exported, and so on. So there's always been regulation. For some reason, it could be an economic reason to keep the goods all inside, to steer the economy in a certain direction. For religious reasons, say, no, you may not engage, you may not do certain productions, and so on. So the state has always regulated economic activity, obviously at the level in which the state was, well, 4,000 years ago. Even in the Roman Empire, there was regulation of economic activities. We find a whole lot of regulations which regulate various economic trade, mostly trade, but also mining, excavations, and shipping activities, and management of infrastructures, typically ports. So there's always been, according to the dimension and the situation in which the state is, whether it is an advanced state, there's always been regulation of economy. And this regulation is not only the fact that the state wants to somehow control what happens within its territory, which is sometimes legitimate, sometimes less legitimate. It's just a way to extract money, regulation, a way to extract money. but mostly starting from the Middle Ages, when we see that modern economy starts. Look at Tuscany, for example. We've seen this as a model of modern economy, although still at the primitive stage, but the modern economy starts there. Enterprise, banking, trade, markets, and so on, and obviously legislation, a whole lot of laws in the field of trade and banking. The regulation is not only the imposition of a very severe state that wants to impose its laws simply because the sovereign feels that things should be done in a certain way. Since the Middle Ages, we find that regulation really is somehow the result of implicit agreement between the state and the enterprises, or the group of enterprises which are regulated. What happens? The state says, listen, I want to regulate your activity for mostly tax reasons, and because this is a strategic activity, and so I want to know exactly what you're doing. Just think of production of arms. Obviously, in the Middle Ages, well, production of arms was very important. If you had arms, you were strong, you had a strong army. If you did not have arms, you had to import them, well, obviously, you were in difficulty. So what you say, oh, well, am I going to control production of arms or of precious metals, gold jewelry, because I want to be sure, I want to know where these goods go to. But at the same time, and that is the intent of the state, but at the same time, the enterprises say, well, okay, you can regulate us, but we want this in exchange. And what are these, what do the enterprises ask in exchange in the Middle Ages? And they ask now. So it's a history that has been going on for the last more or less 8 centuries. We want exclusive rights. We want to be the only ones that provide these kinds of services. We think of telecommunication service. We are the only ones who provide these services. Nobody else can do it. Then someone comes along and says, I will provide these services. Transport services, only I can provide these services. Nobody else can enter the market. So it's a way of somehow regulating the market and the access to the market. So that group says, okay, you regulate it, but we want to be sure, we want to know who comes in. So it must be restricted. Or, and this is limitation to competition, limitation to access, or tax benefits say, okay, that's fine, but we are willing to be regulated, but we want taxes should be structured in a certain way. They will be on certain aspects and not on others. So it is some kind of fruit of political negotiation between government and economic groups that are behind that industry which is regulated. And this is what happens constantly in whatever part of the world. The state would like to regulate a certain sector, and the enterprises say, well, yes, but this, yes, this, no. And so it is, and at the end of the day, because regulation to be effective must be followed. And it can be followed only if it is somehow, the regulation is the result of some kind of implicit agreement. So there's a draft regulation, this is analyzed, the associations which represent those enterprises start analyzing and saying this yes, this no, and so on. So just to point out, this is very much regulation. So we see that this is this hyper-regulation, but it's not only the bad state, bad government, bad institutions who want to impose their regulations. There's sort of this phrase that the business of government is not the government of business, but really business often wants to be governed because it feels protected. It says, well, I'm working in a certain sphere, I have certain rules, I know I follow those rules which I have contributed to write, and therefore I feel more safe in my activity, and I know that nobody will come up and say, hey, but why are you doing this? I say, I'm doing this because I'm following the regulation. So just to point out that this is the kind of how regulation develops in modern societies, modern starting from the Middle Ages, and we are interested in seeing how it operates in Western society. So jumping from Middle Ages to contemporary times, and mostly the last 50 years, we can say 50 years, more or less, it's a good period. Regulation has it's not only the objective of the state when regulating economic activity, is not only the purpose is that of extracting taxes and ensuring that certain things, certain activities are done in the general interest, but increasingly the role of the state when it imposes regulation is the pursuit of social objectives: protection of environment, of public health, consumer welfare, lower income groups. Well, obviously, social objectives, obviously we can put here, let's put also here something more, just let's put workers. So, their social interests, the state regulates because it feels that these interests are important and that therefore regulations should somehow aim at pursuing these kinds of interests. Now this is very complex because while originally this agreement, this regulatory agreement between the state and businesses was only two parts of this negotiation. Here we find a whole lot of other stakeholders that come along, groups, environmental groups who say, listen, if you want to regulate that kind of industry, just think of steel industry, well, you must protect environment. And then obviously you have those who say, well, but this, you must protect also health, just think of warnings on cigarette packets. Then obviously we want to protect consumers, and therefore we want to be sure that the kind of product that is sold to consumers are sold in a certain way. And then we want to protect also people who do not have resources, and therefore we are going to regulate, just think of public utilities, water, electricity, gas, and so on. So they must be regulated in such a way that the tariffs that apply to electricity, to gas, to energy should somehow be available to lower income groups. They can't simply have no electricity at home because they aren't able to pay their electricity bill, or they have no heating because they haven't been able to pay gas. So just to point out, it's the kind of how complex regulation becomes increasingly. It's not only some kind of agreement between the state and the business, but involves a whole lot of other interests. Now, when we look at this and we try to see what are the main features of regulation, first of all, we try to understand who is regulated. Keep in mind this, and this is fundamentally, we find this throughout all Western legal systems. The quality, the nature, the content of a rule depends on who sets that rule. So if it is Parliament, it has certain characteristics. If it is the government administration, it has other characteristics. If it is a judge, it has other characteristics. So just keep in mind that obviously, first point is who makes the rules. When we want to look at the rule, we see who has made this rule and what were the objectives of the lawmaking institution, whether it is the Parliament, it is government, or it is court. And this gives us an idea of the kind of the nature of the rule we are examining. We are lawyers, and our role is there to understand the law, to interpret the law, to apply it, or to oppose the law because we think that that law, that rule, that regulation is not is against some other principle. It could be the Constitution or some other law. So just we are interested in understanding regulation, and regulation governs most of our daily life. So first, let's look at the regulators. Who sets this regulation? So there could be a general act of parliament, and typical, the best example is the French Code de Commerce. 1804, Napoleon introduces this commercial code, which concerns mostly commercial contracts and commercial business entities, companies, and so on, and also insolvency. So what is this? This is an agreement between the bourgeoisie that has promoted the French Revolution and says, hey, this is the bill you have to pay. We are those who brought to the end of the feudal state. We've got rid of the king, of the monarchy, and we want, however, we want some privileges to be recognized. And as these privileges, these special rules have been built over the last, well, 6 centuries, well, we want them consolidated in the code, commercial code. So this is obviously a way through which you regulate. You establish what are commercial contracts and what are commercial entities, whether it is a business, a businessman, or it is a company. So this is a way of regulation, but a very broad regulation in which then obviously those who are operating in the economic sector can move about with a certain amount of freedom. Or the same thing, more or less, a Company Act, whether it is in England or the US, well, more or less, there's Parliament or Congress or whatever, call it whatever you want. There's a legislative body that sets broad rules in the field of economic activity. So that's one kind of regulator. Then we find that we have government. Government that falls, generally it is regulation that falls under the competency of ministry. This is run-of-the-mill administration, regulation of a certain activity. Agriculture, you want to set up some kind of agricultural activity, and you have some certain amount of communications, authorizations, which you are asking to the ministry. And the ministry works like any ministry, whether we are talking of Sweden or we are talking of Cyprus, it doesn't change very much, or we are talking of the equivalent in some US state. Well, it's, you know, it's a very sort of run-of-the-mill activity, nothing particularly, it's mostly on a rather soft way, soft in the sense of not very great changes. Things move very slowly. Only when the Parliament intervenes, then will the ministry start intervening. So this is the ordinary activity of government, which somehow regulates a day-to-day economic activity. Then we have these new, let's call them velociraptor. Let's imagine sort of as if we were back in the ages of Jurassic Park. Well, we have these very peaceful brontosaurs, which are ministries, which eat, they only eat vegetables and they're herbivorous. And then we find velociraptor, very fast-moving agencies, specialized agencies, whose main scope is that of regulating. So what they love doing, these agencies, is regulate. Somehow they have a overproduction of regulating, as if they were sort of factories, and the more rules they set, the more they're sort of they're happy with their activity. So it's these independent administrative authorities, sectorial agencies, which have been created in order to regulate the whole economic sector. We've already mentioned independent independent agencies in the field of transport, energy, telecommunications, financial services. We've seen that, but we can see many others. Just think of, this is very sort of common day. We're sort of discussing on vaccines against coronavirus. Now, in order to market a vaccine, you must follow a whole lot of procedures, and they are, in all countries, there are specialized agencies which must control whether this medicine, this drug, in this case a vaccine, can be marketed, and if it does or does not actually do what it promises to do, and what are the kinds of warnings that must be given, and so on. So here we have, it's not an independent authority, but it is a specialized agency which sets the rules on the introduction or the removal from the market of certain drugs. And these are very, very active, because constantly we don't have only coronavirus, we have a whole lot of other illnesses that require drugs, and so it's constantly you have to decide whether a drug has to be put on the market or removed from the market. So, and this obviously has to do with regulation of the economic activities. Pharmaceutical companies depend on this kind of activity. So we've seen who does the regulation. Parliament with great big ideas that end up in rather large net of rules. Then we have peaceful ministries, and then we have these very fast and specialized agencies which are all the time, every day, producing rules and regulations. Then what are the moments of regulation? We have different, this is also important to take notice. This is not opposition. I mean, also we can find these three regulators together. We can find a general law, then we find a ministry, and then we find an independent agency. Just think of telecommunications. We have a law, a general law on telecommunications. Then we have the ministry of, in Italy, we have a ministry that is Ministry of Telecommunications. It does lots of other things, but including telecommunications. And then we have an independent agency on communication. So the three levels are all there. So it's not that if you have to choose one, you're not going to have the other two. You're going to have probably all the three of them. Then differences in the moment of regulation. When are you going to regulate? And here again, keep in mind these two stages that are not, I repeat, in opposition one with the other, but we find them together. We find ex ante regulation. All enterprises, in order to enter the market and to operate it, must comply with pervasive rules. These rules are set. You want to enter the market, you know what the rules are. So it is ex ante. You decide, well, this is, well, I can comply or I cannot comply. I mean, I'm a bed and breakfast, and I want to turn into a hotel. Well, I know in advance whether it's convenient for me to turn into a hotel, to transform my activity in a hotel activity, because I know what the rules are, national, regional, local rules are to run a hotel. So, I mean, I know this is ex ante regulation, so I'm telling you in advance. You want to enter the market, you want to operate it, in it, these are the rules. Then ex post regulation, which enterprises, in order to enter the market, to operate it, comply with precedents of courts and of quasi-judicial authorities, competition authorities, independent agencies. What happens? This is what normally a lawyer does. You don't only look at what the law, what is written, black letter on rules, what is written, printed there. Well, that's obviously the starting point. Then we have to see how these rules have been interpreted. And who interprets these rules? The courts and administrative agencies. There's been some kind of decisions that have been made on various cases, and you try to understand what has happened when there's been conflict in interpretation, or someone has been said you have not followed the rules, and there's been some kind of decision by a court or by some quasi-judicial authority, which explains what is the sense of that rule. Just think of typical when two companies, when this what is called M&A. Now let me go here 1 second. Sorry. M&A, mergers and acquisitions. This is what is quite common in companies. It's like one company wants to merge with another company or wants to acquire another company. So when you want to do this, well, obviously, if it's one restaurant that wants to merge with another or wants to acquire another restaurant, well, not much of a problem. But the companies are medium big, well, then we have issues of competition issues. And so we try to understand what is, now let's see if I can, we try to understand if this is possible. So what do? We look what competition authorities say, what the European Union Directorate General, Competition Directorate General says on mergers and acquisitions, and we understand whether company A can buy company B, or whether this this is an acquisition which is not possible according to competition law. So just to point out that we look constantly at ex post, we see these decisions and we look at them as pieces of regulation. They are the decision on a single case, but they are precedent that somehow give us the idea of how future decisions will be taken. So you see that we find at the same time ex ante regulation, regulations which are printed in the official journal, which are published on the website of the independent agency. And so surely we will follow those, but at the same time we want to, as well, this is why lawyers are about, as the law is always can be leans itself to different interpretations. We want to know what is the authentic interpretation, and we have to look at the courts or those who are empowered with have the power to interpret the law. So we will, that is ex post regulation. And what we have, we have this regulation by adjudication, in the sense that the adjudication, when there's a case, especially if the case is brought to court, these decisions are a form of regulation. And so we have the shift of powers from administration to the judiciary. Just go back to what you've seen in slides 69 and 70 on the new roles of the increasing role of the judiciary in controlling economic activities. So this is something that just to show you how these two aspects of regulation, ex ante regulation, ex post regulation, are both always together. Now, obviously, we are also looking at not only who is regulating, when the regulation comes into when is the moment of the regulation, but we're also looking at the extent, to what extent, how penetrating regulation is. And I've already mentioned, when you look at when we look at the commercial code, which regulates commercial contracts or commercial entities, single companies or shareholder companies and limited liability companies, that is a form of regulation, but that leaves very much freedom, or a certain amount of freedom to enterprises to decide how they want to put into place their activity. We find instead certain forms of regulation which are much more invasive and pervasive, and here the first, highest level, so the maximum level of regulation is that when the public authorities established a number of operators that can do a certain activity. For example, how many can enter a market or run a business? Mobile phone operators. We find in Italy 3 mobile phones. They can't be more. It's not allowed. Well, they were 4, but then 2 of them merged. But it's always a limited amount. Or on a much more simpler scale, just think of the case of taxi licenses. We find in most European towns, not all, that the number of taxi licenses are limited. Not anybody can decide, wake up in the morning and say, hey, I have a car and, you know, I'm unemployed, I'm going to do a taxi service. No, you must buy a license. If you don't have a license, you can't do this activity, and you must, and the amount of licenses are limited. They may be 100, 1,000, depending on the size of the town, but that's the end of the licenses. If you don't have a license, you can't enter the market. And again, the idea of a license, of a prior license, the idea that you must license, if you put this in sort of the etymological sense of a license, it means that it leach it. You are allowed to do this. If you don't have that, you're not allowed, you can't do it. So if you don't have a license, you can't open a bank, that's for sure. It isn't if you have lots of money, you open a bank. No, you need much more than money to open a bank. Or if you want to run a train company or an airline company in Europe, well, you must have a prior license. Otherwise, you can't do this activity. The fact that you have now this lockdown of all airline activities, but if you have an airplane or 2, it isn't that you can set up an airline company just like that and say, well, you know, I have these airplanes and I want to run an airline company. You need a license. So just to show you that this is a way through which regulation is basic regulation. It says who and how many can access the market, and a whole lot of other aspects that I won't analyze now, but just to show you that this is a very pervasive mode of regulation which influences what is the autonomy of the business autonomy. Enterprise would like to do a certain activity and cannot do it because there are no license, it needs a license, or the number of licenses is limited, and everybody, they are all occupied. Everybody else has a license. So this is one aspect. Now let's see if we can go. Sorry, just, well, it repeats this lot, and I'll correct it afterwards. The EU, the European Union, is fundamentally an economic system based on regulated markets. Regulation is a lawyer's business, but obviously it regulates economic moments, and therefore if you don't understand the economy of various or the regulated sector, obviously your regulation is senseless. So you must, to do this regulation, you must know exactly very well what the sector you're regulating is. And so when we look at the European Union and the bulk of the European Union legislation, which is so has such a big influence on our activity, at least in continental, in most Europe, not only continental, because Ireland is in the European Union. So I mean, it's an island, and also Cyprus, so and Malta. So we also have islands, but it's in the role of the European Union regulates economy through various markets, which are sectorial markets, which have a sectorial regulation legislation. Financial markets, energy, telecommunications, transport, agriculture, fisheries, pharmaceuticals, cosmetics, environment, food. Just you go through, you try to understand what the European Union is doing in ordinary times, not in these days, and you find that we have these director generals that pass their time regulating insurance companies, investment funds, electrical companies, networks of distribution of natural gas, mobile phones or internet backbones, airlines, railways, or ferry lines, and obviously agricultural, fishery, all the rest. So just to show that we have a whole system. The European Union is a system mostly based on this kind of sectorial regulation, in which you regulate a whole economic sector. Obviously, then we find certain activities that are halfway one side and one other, but this gives you the idea of an economy which is strictly regulated. Now, this is not the only model, because we see, just going to see that there are other sort of regulation is everywhere, but the kind of regulation somehow differs. And I'll bring you to two typical cases. One is, and that have typical cases of regulation that have an impact on private law. What we are interested in seeing, the sort of, when, as you are studying, our Italian students are studying private law this semester, just to understand that regulation has a very strong impact on the basic and fundamental rules of a private law that you are studying. So first element, competition. So what do we find here? Just to point out, if we look at a sort of European Union, we find two fundamental articles, Article 101 and 102 of the Treaty on the Functioning of the European Union. And here, what do we have? We have limitations to private autonomy of enterprises. Obviously, not all enterprises, but of many enterprises, especially if they're medium and big enterprises. So, for example, prohibition of agreements or concerted practices that are harmful to competition. So you would like to do a contract with your competitor, somehow trying to find some kind of agreement which is convenient for both parties, but you cannot do it if that agreement limits competition and has a harmful effect to competition. For example, you agree on the prices. You say there are two providers of a certain service in a town, and they agree that they will practice the same price. And so anybody that comes to town and wants that service finds no competition on the price. So that obviously limits competition, and obviously is harmful to clients and consumers. Or prohibition of discrimination against competitors or clients. So you say, well, I'm not going to sell to so-and-so, or I'm not going to buy from so-and-so. So discrimination. Or I'm going to apply different prices. So if it's a friend of mine, I will apply a price of 100, but if he's not a friend of mine, I will apply a price of 120. So that's discrimination, the same product or same service, and discriminatory prices. Or limitation of production or segmentation of markets. Typically, one company says, I will do Northern Europe, you do Southern Europe. And that is segmentation of markets. So the only two companies in Europe that provide that service or those goods, and they divide the market and say, I will do North Europe and you do Southern Europe, and we won't compete one with another. And then further, we find that although in sort of from a legal point of view, all companies which are structured in a certain way, let's imagine a limited liability shareholder company, has from company law the same duties, rights, and obligations. So apparently, if we read the black letter of the Company Act or the Commercial Code, we find that these companies have the same situation. We see that there are some companies that are different from others, and these are companies that are businesses that are in a so-called dominant position. What is dominant position? In Europe, we feel that if a company holds 40% of the market, it is in a dominant position. And it has, I'll put it among brackets, special responsibility. What does this mean, special responsibility? It means that it has limitations on its private autonomy. It can't do whatever it wants. It can't say, oh, but it's freedom of contract. I decide what I want to do. No, they cannot refuse to provide goods or services. So, for example, Coca-Cola, just to take a typical case, Coca-Cola can't say, which is a dominant company in the market of sparkling soft drinks, can't say, I will refuse, I will not provide Coca-Cola to that supermarket because that supermarket is selling also Pepsi. If you want Coca-Cola, you must get away with your contracts with Pepsi. So if you want soft cola drinks, well, it's only me, and you have to get rid of everybody else. No, sorry very much. This exclusionary behavior is not accepted. So this is a typical exclusionary practice. So just to show you that in the competition law has significant effects on private law, establishing what companies may do or may not do, and what companies must do, as in the case of companies which are in a dominant position. They have an obligation to contract. They must sell their products. They must provide their services. If they don't do it, they will be against the law and they will be fined, and you can bring a case for damages against them. Now, just let's go back to, sorry. In competition. Now, this is the European approach. We see in the US, please remember that the US again is forerunner in this field as in many others. We see that, well, competition law was introduced in the US in 1890, and so you see that this is well, it has 130 years ago. If you think that in Italy competition law was introduced first time in 1990, that is 1 century later, and in the rest of Europe in the 70s, that is more or less 80 years later, you understand that the US has a very long tradition in competition law. Now, this is not to say that it is the same thing, and I just like to point out that in the US, competition law is entrusted on the one hand on the Department of Justice, which brings a case against companies feeling that this company is behaving, or companies are behaving against competition, and then generally the courts decide if the company has behaved or has not behaved in an anti-competitive way. So the great importance of the courts in establishing what is against or not against competition. Clearly, if you are an American competition lawyer, obviously what you will do is look at the precedents of the Department of Justice and precedents of the courts to understand if the courts have decided certain practices are or are not anti-competitive. So just to point out that the approach in the US is Americans somehow prefer, the American system prefers to have intervention by the courts. But this intervention by the courts is often very, very effective, and we shall see it in a moment when we look at consumer protection. Now, this is another area of very important regulation, and it has to do mostly with contracts or extra-contractual liability. So we're talking of real private law, core of private law, two institutions, contract and delictual liability. So in what do we have? That in consumer contracts, regulation sets a mandatory content of contracts. So it's not left to private autonomy. It's not left up to the autonomy of the parties. It is somehow related to regulation. Regulation establishes what is the content of the contract. So first of all, no unfair terms. Consumers have the right to withdraw. So the contract is concluded. The other party is bound by the contract, but the consumer can, within 10 days, 2 weeks, can withdraw from the contract. There can be no excessive penalties, so limiting the possibility of the business to set penalties. When it comes, if there's a controversy, you have two systems. You have an alternative dispute resolution system, and you have a judicial solution of the controversy, but the court is not some distant court where the consumer has to go and spend lots of money, but it is the neighboring court which somehow is there, the neighboring court of where the consumer lives. And we have provisions on damages, minimum compensation, so how much the businesses must pay if they don't perform properly the contract, and businesses must be insured. Therefore, if there is some damage to consumers, the insurance will pay. And then we have strict liability of consumers. Strict liability meaning that if there's a damage, they will have to pay automatically for the mere fact that the damage has occurred. And then we have class actions, the fact that consumers can join together and take an action against the company and not act individually, one small consumer against a huge multinational company. And if we look at the various over the last somehow 35 years, we see that of EU legislation, we find financial contracts, transport, tourism, sale, contracts of sale, online transaction, and so on. So a whole lot of contractual activity. When one of the parties is a business, another party is a consumer, well, the rules are significantly changed, significantly modified. Ordinary private law rules have changed, and there are substantially regulation. So consumer protection is regulation of business activity towards consumers. Now, this is somehow a European model, and but we see again some differences with the US model, because in certain areas the models are quite similar. Financial services or telecommunications, we see regulations are the same, but in other areas the US has a different mixture, a different blend of ex ante and ex post regulation. So lighter regulation there's this so-called Uniform Commercial Code, which is not really a code. It's a pretty short law which concerns contracts and securities, which is it has been adopted by all US states, and so it is somehow sort of, it is valid except for Louisiana. It's valid throughout the US. All the states remember that these aspects in the US belong to the state and not the federal government. And so, but if you look at the Uniform Commercial Code, we see rather soft regulation of consumer contracts, but we have a very, very strong ex post judicial regulation. And we see a whole lot of cases, and so we wonder, how is it possible? And we see cases in which the judges, US courts, award 10, 50, 100, 200 million dollars to one single plaintiff for punitive damages in order to, because the company has, this business has violated certain rules, especially it's done, put into place, sold the defective product. So what you do, you hit one company and you think that everybody else will somehow will learn the lesson, will understand that it is very risky to put into production a defective product, because you will suffer very multi-million damage awards. So just to point out that this is a typical case of regulation through adjudication, and which the courts play a very important role. Is it efficient? Well, obviously the US, they feel this is efficient. We somehow feel that it's not so efficient, and we much prefer to have sort of very broad and wide ex ante regulation, and then leave a limited activity on the courts. So these are, just to point out sort of how regulation influences economic activity, but at the same time influences significantly private law, whether it is or private autonomy of companies and what companies may do or may not do. At the same time, certain contracts, typically contracts with consumers. So this is more or less what I wanted to present today to you, and just wanted to see if there are any questions. Listen, I wanted to tell you, I was thinking that next week, and this is for our Italian students, so, okay, Demofonte, I'll talk about mergers and acquisitions. Just before people start disconnecting, I was thinking that next Wednesday, on the 8th, what we could be doing is a mock test. Someone asked me what you mean by if the thing will be oral. Obviously not, because how can I do a mock test, an oral test with 50 or 60 of you? But what I will be doing, and I will be, we will be devoting the lesson. So I think on next Wednesday, I'll confirm this, our foreign students, our Erasmus students who are connected, can skip the lesson. I will be giving you at the beginning of the lesson, I will be giving you, putting on the screen a series of questions on a topic, and I will ask you to, in the 1.5 hours of the lesson, to answer to these questions in English. It's a mock test. I won't grade anything. What I will do is, if there are some general mistakes of presentation, I will tell everyone, listen, many of you have done this certain mistake, and then I will try to respond individually to those who have made individual mistakes. But it's a way to test, first of all, your language skills. If you are able in an hour and a half to write some reasonable things in a decent English. I'm not interested, you don't have to be Shakespeare English. You must be sort of a decent English, understandable English, and you start reasoning with a legal mind. You're your first year, so it takes time before you capture a legal mind, but I will try to put you some questions to which you should reply from a legal point of view. I mean, not because, I mean, they're not only lawyers in this world, thanks God. We have doctors, engineers, and businessmen, and traders, and farmers, and you can do lots, and artists. So lawyers are not the salt of the earth. But if you decide you want to be a lawyer, you must express yourself in a certain way and reason in a certain way. Otherwise, you're not doing what you're doing something else. So just to point out, obviously, if you are a doctor, you don't speak like a lawyer, and vice versa. So what this will be, the aim of this test will be try to bring up your skills in this field. But I'll give you further information. We have time until next week. Now, Demofonti asked me, sorry, I didn't understand what is the merger and acquisition. A merger and acquisition is M&A, is a formula by which what happens? There's one company that wants to buy, company A wants to buy company B. Now, when you want to buy company B, obviously, it's not only a question of price. You want to understand what is the price, what are the business opportunities, whether company B has some skeletons hidden in the cupboard, and therefore, once you buy company B, you've bought all these skeletons. Typical example, company B hasn't been paying taxes for many years, and after a certain amount of time after company B has been bought, the tax authorities say, hey, listen, the company B, which now has been incorporated by company A, has to pay 1 million, 10 million euros of taxes. So merger and acquisition is a very complex activity. Among the due diligence, let me write this down if I can, I'll write it on the chat, which makes it simpler. That you have to do when company A buys company B, or when company A wants to merge with company B, are also competition issues. So can you, these two companies merge? Let's make an example. Can Microsoft and Google merge? We say no, obviously no, because they would create would be a huge, very powerful company, but it would limit very much competition. Can, for example, let's go in another sector in Europe, let's imagine, can Fiat Chrysler and Peugeot merge? And so the problem is whether the fact that they merge somehow is limiting competition, and therefore you have to see whether you have to see what is the market for automobiles. Let's imagine we only look at automobiles, not other sectors, and we're trying to understand if the merger between Peugeot PSA and FCA would limit competition. So this is, we have to look at this under the eyes of competition, and we will look to understand if this is possible. We will look at what the decisions, mostly in this case, of competition authorities or of competition of the European Commission, Director General of Competition, if that kind of merger is allowed or not. So we see that when it comes, it isn't that simply you go, you say, oh, that's a wonderful company, and you buy that company. No, you must understand, or you say, two companies say, it would be very nice if we merge, we'll get a bigger share of the market. We have economies of scale, we reduce a whole lot of cost, of duplication of cost. So it's convenient for us to do this merger. We have to see if there's this competition, this merger can be allowed, and one of the main obstacles is competition law. And so we have to see what are the, not what competition law says, because it says, if you read Article 101 or 102 of the treaty, or 101 in this case, or you look at the merger regulation of the European Union, well, it says general principles. We want to know exactly if what are the decisions taken by the Commission in this field. So we will try to analyze ex post decisions to somehow be illuminated, enlightened for the future. So this is I hope I've replied. Giovanni asked, judicial regulation. Remember, go back to slides 69 and 70. We see that increasingly the judicial authorities, the courts, whether we are talking of the courts in the ordinary courts in the US or administrative courts in I'll answer to Anzalone afterwards. It's in the continental Europe, we are going to look at administrative courts. These decisions have a regulatory function, in the sense that often the courts do not limit themselves in saying, oh, but that administrative decision regulation is not valid. But they also say what is valid and what should be done, and what, not only what shouldn't be done, but what should be done. So we find that increasingly in certain sectors, the courts, mostly whether we are talking of ordinary courts in the Anglo-American system or administrative courts in the continental European system, decide how regulation should be, and they set the rules. They don't only decide on a case, but they set the rules. So this is what we call regulation by adjudication. On the test will not be valid. Please don't consider it. It's not going to be evaluated. It's a test to increase your skills, because otherwise what happens when we arrive to exam, then you say, hey, but I've never seen this. This is something completely new. Instead, this is just to see. I'm not going to evaluate. So you can do all the mistakes you want, and often we generally learn more from our mistakes than from our successes. So just to point out that I won't evaluate it. It's useful for you, and it helps me also understand what your level is, because if I don't know what your level in your language skills and your ability to present legal arguments is, well, I will do something. I will not do a proper exam. I'll do something that is wrong, too easy, too difficult, improper. Anyhow, I can't evaluate the class, especially, I mean, at a distance. It's very difficult for me to understand what is your level. So it's with a mock test. No grades, no prejudicial pre-evaluation of students. It's just for me to understand, and for you also to understand the skills. Now,
Thank you.
students concerned with the mock test. For Erasmus students, I will be doing what more or less replicating. We have to see what the lockdown is and how it works and so on. But I tend to do the same kind of exam I've been used to doing in the past years, which is different. I mean, our Erasmus students, whether Anzalone and Locascio, or we're talking of Kid Monday, or Wood, or Shiu, who is in Hong Kong, you are all students which are not in your first year. So you have much, I would imagine, much more skills, and also your language skills have been tested. Otherwise, otherwise you would not have enrolled in this in this class knowing that it was all in English. Well, obviously, she would, a mundane kid, obviously have very good English skills, and I see also Anzalone and Lukash have good English skills. So just to point out that I will be doing the same kind, and I will explain to them also because their class is slightly shorter. It is a 7-credit course, while for Italian students it's a 9-credit course. So the Italian students will have a longer prolongation of their classes when the Erasmus students will have finished. So Erasmus students will have a kind of test which is an open book test. I will give them some a list of questions, and they must somehow reply hypothetical issues, legal issues, just to make an example. I mean, just not because I just want to. Among the 8 questions, there was the case of some Arabian prince that comes over to you and asks advice and say, "Can I come to your country with my 4 wives? And is it all right for you if I register as a citizen of your state and but I want my 4 wives?" So polygamy. So the issue of polygamous marriage in a country. So is typically a European country, but we also had last year I had Turkish students, so there was also not sort of European, partly European country, but with Islamic State. So just to point out, so just give an answer, reply, open books, and give me a reply to this question. There was a list of questions that had to be answered. For our Italian students, I will do something much more simple first year, because therefore you do not possess all that knowledge. You're starting to enter the legal arena in this year, so you're still growing, budding young students, law students, and so it will be significantly simplified, which makes no sense instead for Erasmus students, which are surely not in their first year and have superior skills and superior knowledge than first-year students. So I will make a different kind of exam, tailored obviously on students, because I want to evaluate students. I'm not an abstract student. I want as a class. First-year students are one class, Erasmus students are a different class, and I think one has to adopt different methods. Musti asks, is it possible to have these slides tomorrow? Well, I'll do my best to put them together. And please, if there are further questions, just write to me, and I will try to answer to everybody. Good afternoon to everybody, and have a good evening, and see you tomorrow always at 4 o'clock.
Thank you. Good afternoon.